Welcome, everyone. Thank you for being here for Palmetto Academy's Unit 4 hearing as part of the We the People National Invitational. My name is Ryan Susky. I'm the Director of Programs over at the Ohio Center for Law-Related Education, and I'll be your facilitator for the hearing today. In just a moment, I'm going to have the judges introduce themselves, and then, of course, we'll have the students introduce themselves as well before we begin the hearing. The hearing takes the form of a 4-minute prepared statement from the students, followed by 8 minutes of follow-up questions from judges. Now, I'll have my microphone muted during the hearing, but I will be holding out time cards, so we recommend that you go ahead and put your computer in gallery view so that you can see my time signals and, of course, your colleagues throughout the hearing. When the hearing is finished, judges will give some brief feedback, and then we will conclude. So with that, I'll go ahead and hand things over to your chairperson today to go ahead and begin the introductions.
Hello, it's nice to see you again. We're going to introduce ourselves and then we'll ask you to introduce yourself and your teacher, and then we'll get started. I'm Deshawn Whitaker, a We the People teacher in Charles County Public Schools in Maryland.
And Joe Stewart in the Political Science Department at Clemson University.
And I'm Diana Owen. I'm a political science professor at Georgetown University in Washington, D.C.
My name is Sophia Obiena.
My name is Eliana Hart.
And my name is Sadie Case.
Great.
All right. We're going to go ahead and get started. This is Unit 4, Question 2. I did it again. All righty. If a law has been properly passed by the lawmaking branches of a democratic government, why should judges have the power to declare it unconstitutional? Do you agree or disagree with Robert Dahl? Why? What is judicial review and why is it controversial? What has been the impact of judicial review on American society? Once the Supreme Court has decided that a law is unconstitutional, what power, if any, do the people have to change the Constitution? You may begin.
Robert Dahl's philosophy is correct. Judicial review is not needed. While the other side argues that it adds another set of checks and balances, strengthens the government, and protects the Constitution, it can fail to uphold the majority will of the people. Jefferson wrote, "The opinion which gives the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, would make the judiciary a despotic branch." Judicial review was first established in 1803 in the case Marbury v. Madison. Judicial review specifically gives power to the government to decide whether or not the legislative and executive acts are constitutional. As Jefferson wrote, "The Constitution is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please." Judicial review is an implied power from Articles 3 and 4 of the Constitution. Judicial review disregards the democracy of our nation. Laws are discussed, debated, and negotiated by representatives elected by the people, not appointed by a partisan president, and most likely confirmed by a faction Senate. You see this with President Obama's Supreme Court nominee, Merrick Garland, or under the leadership of Senate Majority Leader Mitch McConnell and President Trump nominated and confirmed 3 Republican justices. One way to solve this dispute is voting on Supreme Court justices or to add it to the number of justices.
The principle of judicial review has its roots in the principle of separation of powers introduced by Baron de Montesquieu. Judicial review appeared in Federalist 78. Hamilton first disposed of the idea that legislators should be left to enforce the Constitution upon themselves. A Constitution is in fact and must be regarded by the judges as a fundamental law. Marbury v. Madison expanded the power of the judicial branch. Since Marbury, the Supreme Court has greatly expanded the power of judicial review. In Martin v. Hunter's Lessee, the court ruled that it may review state court civil cases arising under federal or constitutional law. In 1958, the Supreme Court extended judicial review to mean that the Supreme Court was empowered to overrule any state action, executive, judicial, or legislative. Today, there is no serious opposition to judicial review. In Brown v. Board of Education, the Supreme Court struck down state laws for violating the Equal Protection Clause of the 14th Amendment. In Gideon v. Wainwright, the Supreme Court forced states to provide counsel in criminal cases for indigent defendants who were being tried and could not afford their own counsel. Also, in Loving v. Virginia, the Supreme Court struck down a Virginia statute that prohibited interracial marriage on equal protection grounds. In Roe v. Wade, the Supreme Court struck down state laws that made abortion illegal. National Federation of Independent Business v. Sebelius upheld most of the Patient Protection Act and Affordable Care Act. The people do not have much power to change the Constitution, and this is one of the main reasons why judicial review remains controversial. Once the Supreme Court rules on a constitutional issue, the judgment is virtually final. Its decisions can be altered only by amending the Constitution, a new law passed by Congress, or a new ruling of the court. The nation's high court has overturned 236 rulings in its history. In 1896, the Plessy decision was overturned by the 1954 Brown decision. Chief Justice Marshall expressed the challenge. We must never forget that it is the Constitution we are expounding, intended to endure for ages to come, and consequently to be adapted in the various crises of human affairs.
All right, thank you for your testimony. I have a question for you. Do you believe that judicial review is critical in protecting the rights of the minority against the will of the majority?
I believe so, because in cases such as Gideon v. Wainwright, where he was not having a attorney with him, where he could not afford an attorney, it was shown to the Supreme Court so that he could be protected with his minority point of view, so that he would be able to have the same due process laws protected under our 5th and 14th Amendments.
I agree with my partner. I believe that judicial review helps protect the opinions of the minority, like in Gideon v. Wainwright, but to take an alternative view, when judicial review was established, it was established by the judiciary without the legislative branch or any other say with the people. And because of that, we've been relying so heavily on it, and they've used little judicial restraint to contradict it. Yes, I agree with both my partners. Like in Brown v. Board of Education, this overturned the Plessy v. Ferguson case, which the Plessy v. Ferguson case resulted in segregation, while the Brown v. Board of Education overturned this, which helped.
We also have Schneider v. Phelps, where they had the Baptists against the military.
Okay. You mentioned restraint. When I hear about judicial review, I often hear it discussed in terms of judicial activism and judicial restraint. What is judicial activism, and what's the relationship between that and judicial review?
Restraint? Okay.
Restraint or activism, they look at it.
Okay. Judicial restraint is the ability for the court to have to limit its use of judicial review. It's what helps check on judicial review, which gives the court a lot of power to say what a law is, which is why judicial restraint is so important in today's world.
It also gives us another set of checks and balances on the government. Just as judicial review gives checks and balances to the legislative and executive branch, they are able to make sure that the judicial branch is also in check, so that they are not becoming tyrannical.
Jefferson believed that the judicial branch would be despotic. So they had to make sure, like what my partner said, checks and balances keeps the branches in check.
So in your opening statement, you mentioned a concern about having justices of the Supreme Court, especially appointed by partisan presidents. Do you then believe that the Supreme Court justices should be elected by the people?
Absolutely. If they are not elected by the people as they are now, I feel that this gives way too much leeway in our Constitution, as it was set up to be a more Republican represented, where we have our elected officials representing us. If they are appointed by a president, that sways their judgment and their ways of being able to determine certain laws for the people. So let's say that the people are saying that we need more like if a president is one way than another, then they will most likely take the president's way because they were put into power by the president.
I agree with my partner. I believe like Locke's philosophy. He always believed that people should have the power to have the opportunity to have things like, for example, appoint justices to Supreme Court.
I agree with my partner, Eliana and Sophia. We are a majority rules country, and if they are appointed by a partisan president, the people don't have a say in the court cases and its rulings.
But to take the other point of view, electing it by the president also makes sure that our court doesn't always take too much leeway from the people, and will also have more of an inside point of view.
Yeah, I mean, let me ask here. There have been surveys that have done classes like yours have gone out and taken the Bill of Rights, the first 10 amendments out on the street, and they get called all sorts of names, and people say, oh, this is a terrible idea. What if the people would vote down freedom of speech, freedom of religion, freedom of the press? Do we want that kind of popular sovereignty?
Absolutely not. Even though we should have a representative of judicial review, they still have the power given to them so that they can protect the Constitution and the Bill of Rights as it was passed in the beginning. As Alexander Hamilton states in Federalist 78, they are given the power to be able to make sure that anything that contradicts the Constitution is not going to be able to completely undermine what they have been able to create and what has lasted so long.
I agree with my partner, but to add something, there is a philosopher that we were just discovering, the Ethiopian philosopher from Africa, Zara Jacob, and he believed that everyone's equal and that everyone has a say in their religion and that all religions are right because that's what the people believe. So I agree with this. I believe that it's correct, and Zara Jacob did too.
All right, so if you had the people elect the justices, how do you feel about the justices serving a life term? Do you think that's right, or do you think we need to change that?
I believe that justices shouldn't serve a life term because if the president that appoints them can only serve 8 years maximum, then why should the judges they appoint serve life?
To take in an alternative route, I do agree with my partner, but the founders believed that the justices should serve life terms so they wouldn't have biased opinions from the other branches and the people in the government.
I hear what my partner is saying, but I also disagree with this point because back in the times when this ideology was created, they weren't living as long as we are now. Also, in our state of South Carolina, we have a limit of 72 years old. And I think this really sets a great idea so that other new ideas can be flowing through the Supreme Court and that we don't have tyranny among the one person and their same idea.
So each of you is constitutionally qualified to be a federal judge. Would you support some other type of qualifications being placed on federal judges other than the president nominating and the Senate confirming?
Absolutely. I think Americans today especially are not as educated as they should be. I think with they have to be able to go through at least law school to be able to understand the laws that are.
Finish that sentence.
I apologize.
What you learned from
the
law
laws that
school.
are put into place and that they are supposed to be protecting.
Okay, thank you.
All right. You did a really great job today. I like that you took a clear position on the quote from Dahl. You said you agree with him, and you talked about why you agree with him. I like that you mentioned this faction Senate, and you talked about the controversy behind the Merrick Garland nomination, as well as Trump and McConnell, and how I like that you brought in those most recent events that help strengthen your arguments. I like that you brought in court cases as well. You talked about Brown, you talked about Gideon, you talked about Loving, just to name a few, because you did name a couple more as well. And I like that you were able to respectfully disagree with each other and agree with each other. Everybody had a different opinion, and you were able to cite why you felt that way and provided evidence as to why, the evidence that supported your claims. I'd like to talk a little bit more about the election of the justices, and your thoughts about how in your state they do have a 72-year-old limit. Whether or not you think that's pretty appropriate, or maybe we need to change that up a little bit. Is 72 the right age, or maybe not? But overall, and I wanted to talk more about the qualifications as well, but we ran out of time. Overall, you did a really great job today, and I enjoyed speaking with you.
Yeah, I agree. I thought you did a good job. You were clearly enthusiastic about this. You had thought about it a great deal. At times I wanted to say, okay, let's slow down and think this through. But I wasn't going to try to stand in front of this train. You were really excited, and I try not to curb excitement like that. Long listing of cases, all of which were appropriate, and talked about things like the amendment process, and gave us the exact number of laws that have been overturned, which was very helpful. So I thought you did a good job. Thank you very much for your participation in the program, and for being involved with the We the People program.
Yeah, I have to agree with my colleagues. I thought you did a really great job, and I also was very impressed by your enthusiasm. I have to say, for us at least, we've been doing this all day, and it's going to be a long day. And I really appreciated the fact that you were upbeat, and you knew your stuff, and you were excited about telling it. And I just really appreciated that. I thought you started off, from the get-go, you were very strong. You took a strong position, which could even be a bit of a controversial position, except that, you agree with Jefferson, and you brought up Jefferson, you had quotes, and you brought in more recent evidence that you had to support what you thought was, the key points of his case. And I thought that was really, really smart. And I like the way that you talked about how it was implied from the articles in the Constitution, that it wasn't, and you were very specific about where that was. I also agree with Dr. Whitaker about the fact that you related the political, nature of the appointment of justices to kind of recent history, which I thought was really quite good. You also brought up a number of philosophers, going back to Locke and others, and even more recent ones. And I thought that was really brought a lot to your presentation. I think, just very thoughtful in the way that you answered the question. Oh, the other thing that I really liked was when you all agreed with a particular position, you would then say, but there is another side to it, knowing that you knew the other side, but that wasn't your position, but that you were aware of where other people stood. So just a very strong performance, and it was a pleasure to talk with you today.
Thank you so much.
Thank you.